Hello, everyone, and welcome to Uncivil Law. And for today, we have a follow-up decision that was just rendered as it deals with men and the draft. You may remember this case from when we covered it at the district court level. And you may remember this case when we covered it at the Court of Appeals oral argument level. And I very famously said there was only one decision the court could read, and many people in the chat were dubious. They're like, no, there might be other decisions. Well, the United States Court of Appeals has just rendered its decision, and we're going to read it together. This is National Coalition of Men versus Selective Service System. In this case, a bunch of men said, hey, the selective service discriminates on the basis of sex, and it doesn't make sense anymore, and they should stop discriminating on the basis of sex. Women should be required to register for the draft too. So, what did the Court of Appeals have to say? Well, the Court of Appeals decision is only 6 pages long, because there was only one decision they could come to. So it didn't take a whole lot of words. So let's cover the decision in this case. Let's get started with this. The plaintiffs, National Coalition of Men, sued the defendant, the U.S. government, and its director, alleging that the male-only military draft is unlawful sex discrimination. The district court granted the motion by National Coalition of Men, holding that requiring only men to register for the draft violated their Fifth Amendment rights for unequal protection of law. Because the district court's judgment directly contradicts the United States Supreme Court holding in Rostiger, and only the United States Supreme Court may reverse its precedent, we reverse. Yeah, the district court got this wrong. Let's discuss why. The Military Selective Service Act, the Act, essentially requires all male citizens and immigrants between the age of 18 and 26 to register for the draft with the Selective Service, a federal agency to facilitate conscription. Men who fail to register and otherwise comply with the Act and its implementing regulations may be fined, imprisoned, and or denied federal benefits. The Act does not require women to register. Yeah, of those, the most notable for men is the federal benefits. It would deny you access to certain federal loans, certain federal grants. It can be certain federal jobs. It's a pretty big deal for men, especially if you're seeking higher education. So failure to register can be a pretty big deal. So, the U.S. government finding you or the U.S. government putting you in jail is more of a, that's not going to happen. But the denial of benefits definitely will happen. And women don't have to register for this. So isn't that discrimination on the basis of sex? All right, let's read on. In 1981, the Supreme Court held in a case called Rostiger that male-only registration did not violate the Due Process Clause of the Fifth Amendment. The court based its reasoning on the fact that women were barred from serving in combat and deferred to congressional judgment about how to run the military. So in 1981, women couldn't be in combat. So the Supreme Court, that was the factual underpinning. Since then, the military has gradually integrated women into combat roles. In the early 1990s, Congress repealed the statutory bans on women serving on combat aircraft and ships. In 2013, the Department of Defense announced its intention to open all remaining combat positions to women, the last of which opened in 2016. And on the previous stream, I stated I was uncertain at the time if that applied to submarines or not, because I was uncertain. And I've since learned that yes, women do serve on submarines. They serve on the largest class of submarines, and there's been a gradual integration. But yes, women do now serve on submarines, so women can serve in every combat role that's available to men. That's obviously a massive change in the factual underpinning. We went from a situation where women can't serve in combat roles to women can serve in all the combat roles. So that undermines the rationale of the Supreme Court decision. But nevertheless, it's the Supreme Court decision. So does the fact that the decision, the logic of it has been undermined, does that change the holding? No, it doesn't. So let's press on and discuss why. Congress again considered male-only registration in the context of the 2017 National Defense Authorization Act. The Senate version of the bill would have required women to register, but the final law instead created a commission to study this issue, among other questions, whether it needed to proceed, and the commission completed its report in March 2020, so relatively recently. So if you're interested in that, you can go read that report. The 2017 National Defense Authorization Act also directed the Secretary of Defense to issue a report addressing, among other things, the benefits of the Selective Service System and the impact on those benefits of requiring women to register, which the DoD has completed in 2017. So there's been some changes in the factual underpinning on the congressional level as well. The plaintiffs, the National Coalition of Men, sued the government for violations of their Fifth Amendment right to be free from sex discrimination. On cross motions, the district court granted the summary judgment for plaintiff appellees, declaring that men-only registration was unlawful, but declined to issue the injunction. The court reasoned that Rostiger no longer controlled because women now served in combat. Yeah, the district court screwed that up. The government appeals, asserting that Rostiger does control, and regardless of Rostiger, male-only registration is still constitutional. So we have to discuss the precedent that applies, that is binding on this case. So let's do that. In Rosker, the Supreme Court held that male-only selective service registration did not offend due process. The court relied heavily on the legislative history to show Congress thoroughly considered whether women could be required to register. At the time, women were barred from combat, so the court examined the constitutional claims with those combat restrictions firmly in mind. So yeah, this was a factual underpinning for the Supreme Court. The court concluded that this is not a case of Congress arbitrarily choosing to burden one of two similar groups, men and women, because the combat restrictions are not similarly situated for the purposes of draft. Men and women may in fact be different, yes. Further, the court rejected the district court's conclusion that women could be drafted in some number of non-combat positions without denigrating effectiveness, instead deferring to Congress's determination that administrative and operational burdens exceeded the utility of it. So they said, yeah, there might be a burden to this. The draft exists primarily to get people into combat roles. So even if we could get women in non-combat roles, that's not the purpose of the draft. It goes to Congress's purpose. Fair enough. That holding from the Supreme Court is holding on this court, which is why there's only one possible outcome. The Fifth Circuit is a strict stare decisis court and cannot ignore a decision from the United States Supreme Court unless it's directed to do so by the United States Supreme Court. Only the United States Supreme Court can overrule its own precedent. The United States Supreme Court is clear on this point. In State Oil Company versus Kahn, the court held that a vertical pricing mechanism was not per se unlawful, overruling a prior case. The court disagreed with some of the reasoning of the prior case, but relevant to this case, also found the facts had changed. The court nevertheless noted that despite the infirmities in the prior case and its increasingly wobbly, moth-eating foundations, the Court of Appeals was correct in applying the principle, despite disagreement, for which this court alone overruled the precedent. So, yeah, there is a precedent on this issue. So there's two precedents that are valuable. There's a precedent dealing with whether or not women have to sign up for the draft, and there's a precedent dealing with what happens if the foundations of a precedent are shaky. So in a case called Rosker, the United States Supreme Court said, yeah, a male-only draft is constitutional. It based that decision on the fact that women were not in combat roles. So the factual underpinning of the case is now completely worn away, right? But the holding is still valid. So what happens if you have a case that the factual underpinnings of which have been eroded? Well, we have precedent for that too. And the Supreme Court said, yeah, even if the factual underpinning is invalid, the holding is the holding. And only this court, the Supreme Court, can overrule it. So yes, the factual underpinning for Rosker is undermined. But there's only one decision for this court. There's only one decision. So the district court screwed it up. And the Court of Appeals says, yep, Rosker says women only draft or men only draft. Yep, that's constitutional. The fact that the factuals have completely changed is irrelevant because there's a Supreme Court opinion that tells us that. So there's only one thing for us to do, reverse the district court. If the Supreme Court wants to overrule Rosker, that's up to it. And so you could appeal if you want. Let us know how it works out, I guess. Here, as in the case of State Oil, the factual underpinning of the controlling decision has changed, but this does not grant this court license to disregard or overrule the precedent. See also Roper. Only the Supreme Court may overrule its own precedent, even where some subsequent decisions or factual developments may appear to have significantly undermined the rationale for its earlier holding, and therefore a majority should have admonished the circuit court despite affirming the judgment. See also Rodriguez versus Sheraton. If a precedent of this court has direct application in a case, yet it appears to rest on reasons rejected in some other line of decision, the Court of Appeals should follow the case which directly controls, leaving this to the court the prerogative to overrule its own decisions. And see also Agostini versus Felon, confirming the rule from Rodriguez that a lower court may not conclude that recent cases have by implication overruled a precedent. So this case has come up before the United States several times, United States Supreme Court several times, in several cases. And several times, the United States Supreme Court has said whether or not there's been an undermining of the facts, whether or not there's been an undermining of the law, whether or not there's been somewhere else, you are bound by our precedent. Only us can change our precedent. So if the case comes out the same, it's up to us. So there's only one thing to do. Reverse. The plaintiffs, the National Coalition Men, point to no case in which a court of appeals has done what they asked, to disregard a Supreme Court decision as the constitutionality of the exact statute that's at issue because some key facts implicate have changed. That we will not do. Rosker forecloses that, so the judgment of the district court is reversed and the case is dismissed. So, short of the United States Supreme Court granting certiorari in this case, which I feel is somewhat unlikely, that is the end of our coverage of National Coalition of Men versus Selective Service. We covered the district court, which said, yes, this is sex-based discrimination. And then we covered the Court of Appeals oral argument, in which I said there's only one thing for the Court of Appeals to do. And a lot of people in chat said, no, you're wrong. You're not understanding this. I'm like, no, I'm not wrong. There's only one decision to be made. And yeah, the Court of Appeals, in a very short 6-page decision, made the only decision there was to be made. The case law is crystal clear. The district court just simply made a mistake. They screwed up. They said, oh, the factual underpinnings have been undermined, therefore it's no longer binding. And the Court of Appeals is like, no. The Supreme Court has been very, very clear multiple times, district court, you can't do that. So there's only one decision to be made. So National Coalition of Men could now appeal to the United States Supreme Court. I don't think they're particularly likely to take that. There's not particularly likely for them to do it because Congress is already looking at this issue contemporaneously. And I don't see a lot of appetite or energy for the United States Supreme Court to get involved in this particular fight. But they could try, and they could say, well, they would have a good basis to make the petition for certiorari. So I would imagine they're going to petition, and they have a pretty good argument. The case, Rosker, is no longer good law because it's been completely undermined. So you should redecide this. I think it's unlikely the Supreme Court's going to say yes. The Supreme Court only says yes about 0.7% of the time anyway. I don't think this is in that category of cases, but yeah, maybe the Supreme Court will surprise me and grant certiorari. But with Congress already looking at this, I don't think it's likely. So short of the United States Supreme Court getting involved, that is the end of the coverage of this case. Thank you so much for being part of the Uncivil Law family. If you liked this latest video, please give it a like below and hit the join button. For 99 cents a month, you too can give a recurring membership that helps this channel grow and helps YouTube to recommend this channel to others. We really appreciate your continued financial support and all your love. And until later, my friends, cheers and goodbye.